Calling cause number 4912, Discover Bank versus Mike Piedra. Your announcement for the record, please, Counselor.
Victoria Shiloh for the plaintiff, Your Honor.
All right. This time the court takes judicial notice of the entire court's file. I find that on December the 28th of 2023, there was original petition filed. Looks like Mr. Piedra was served. He had we had a hearing on the plaintiff's motion for default judgment on August the 21st of 2024, where Mr. Piedra made a general appearance. Thereafter, on May the 21st of 2025, plaintiff filed a motion for summary judgment. And then a couple days ago, plaintiff filed a notice of merger. I do not find in my file a notice of hearing for today's hearing on motion for summary judgment, giving Mr. Piedra proper notice of today's hearing.
Okay, Your Honor. If there isn't one on file, I'm not sure what happened. We typically file it with the motion for summary judgment. I know the motion was sent to him.
From my experience, the collection law firms do not usually send a notice of hearing along with their motions for summary judgment. They usually send them separately. I've looked at your motion for summary judgment, and it does not contain a notice of hearing within the motion for summary judgment.
Yes, Your Honor. I am having some system issues, so I'm unable to pull up to see if we did have a notice or not. So if the court will allow a continuance for this so we can get proper notice to that defendant.
Yes, I'll allow a continuance, but I'm resetting this case also for dismissal docket on November the 12th at 9 o'clock in the morning. So this case has been around since December of 2023. So and it looks like we had a general appearance over a year ago and nothing's happened since then. So this is definitely ripe for want of prosecution. So I'll be sending you a notice of setting for the dismissal docket. So whatever you're going to do, you have to get it done before November the 12th.
November the 12th. Yes, Your Honor. Will do.
All right. Thank you, ma'am.
Thank you, Judge.
So now I'm going to call cause number 23-09-0566-CVA Truest Bank, formerly known as Branch Banking and Trust Company versus Espinosa. In this case,
yes,
I'm taking judicial notice of the entire court's file. I find that on September the 12th of 2023, there was an original petition. Mr. Espinosa was served. Mr. Espinosa filed an answer on October the 16th of 2023. You have later filed a motion for default judgment on July the 1st of 2025. I dismissed the case for want of prosecution, and on it's filed July the 10th of 2025. I've reinstated that matter, and then I also set this case for today for a hearing to show why this matter should not be dismissed for want of prosecution. I'm denying your motion for default judgment because, of course, the defendant has filed an answer in this case.
Yes, sir.
So this case is 2 years old. I've already dismissed it once. I'm dismissing it again today for want of prosecution.
Okay, so we can't request a trial setting?
Well, you know what? This is the deal. He filed his answer in October of 2023. So it was almost 2 years ago that he's filed his answer. And really nothing had happened to it. I've already dismissed the case once. I guess nobody took a harder look at it because then we're back here again today and I still can't do anything on the case today. So at this point, this case is getting too long in the tooth. The answer that he filed back in 2023, who the heck knows if he's even at that address anymore for him to even be involved in any trial coming up. So I just don't think it's fair at this point to continue with this case after already dismissing it once and then setting it back for another dismissal docket, and it's not ready to go. So it's being dismissed for want.
Okay. All right, Judge.
All right. Thank you, sir.
Yes, sir. Thank you. May I be excused?
You are excused. Good morning. I'm Judge Bob Brendel.
Good morning, Your Honor.
All right, it's 11 o'clock. Let me call your case. Calling cause number 24-12-0939-CBA Wells Fargo Bank versus Mark Prescino. I'm taking judicial notice of the entire court's file. I find that there's original petition filed on December 13th of 2024. The defendant in this case had filed an answer filed on February the 3rd of 2025. The plaintiff filed a motion for summary judgment on July the 11th of 2025 and sent notice of hearing was served on the 13th day of August. However, the notice of hearing does not give any instructions to Mr. Prescino on how he's going to appear. So I don't think that it complies with this notice of hearing doesn't comply with the rules for a proper notice of hearing. I'm going to drop into the chat a little note regarding the notice court proceeding. In other words, Rule 21 says, subsection B says that notice of court proceeding must contain information needed for participants as defined in Rule 21DA to participate in the proceeding, including the location or instructions for joining the proceeding electronically. And so what I have included are Rule 21 and also Rule 21D, and also this court's suggested language for instructions on how to join a Zoom proceeding.
Okay, Your Honor, I will then reach out to the court to request a new hearing date and then get it as properly noticed.
Thank you, sir.
Thank you, Your Honor.
Did you find the suggested language in the chat that you can just copy and paste?
Yes, I downloaded it to my computer, so I can go ahead and make sure that we got that properly.
All right. Thank you, sir. Have a good day.
Thank you.
Okay, now calling cause number 24-12-0950-CBA in the interest of the Lopez children. And this case was set, let me look at the pleadings. So set on a motion for alternative service. I have a notice of setting, but I do have notes from the court. Let's see. Say anything up there either, but there is on 8/20, there's a First Amendment petition for adoption of the stepchildren. On September the 2nd, there was a filing for a motion for alternative service. This court has already ruled on the motion for alternative service, but it was back in March of 2025, and it was set for a hearing in April of 2025. And in April, and I signed. Oh, here comes somebody. Let me see what case this person's coming in here on. All right, timeout. Let me see who's coming in. Hello?
Yes, Judge, I'm here.
And if not the full amount, you need to make arrangements with
I
her.
apologize. My morning hearing ran late.
Okay.
That's fine. What case are you here on?
The last name is Barraza.
And I know you have a question.
The cause number is
Directly, but you have to speak to your attorney. So I don't know how y'all are communicating.
not on here.
Mrs. Estrada, do you need a breakout room with him for a second, or do you want to call him?
Hold on real
I'm
quick,
hearing
because
other-
I'm so
I'm
sorry.
hearing other voices too.
Yeah, I know. It's because I had a hearing that ran late that got moved over from the morning to the afternoon. It's just a motion for substitute service.
All right.
It's
Okay.
Cause number,
I have another hearing waiting, so.
I have it here. I'm sorry.
All right, let me go ahead and tell you what I'm doing on that so that way you can get back to your other hearing.
Okay.
I'm denying your motion, but in fact, I actually signed an order on your motion back in April of 2025 to allow service the requested address, but now that's too old. I allowed you to do service by posting back in April. It never got done. Now I can allow 5 months later. I'm not sure if the person still lives at this address, so I'm going to vacate my prior order on motion for alternative service. You'll have to attempt service again and do a new motion for substituted service.
Okay, and I apologize, Judge. That wasn't what my understanding was from the former counsel. I just got on the case. She had said that the petition needed to be amended to plead long-arm jurisdiction, and he did that. I can understand if you think that the affidavit is dated, because I believe that the last attempt was in March. But okay.
Order, and she can explain that to you.
But so you're going to have to try to serve them and get me updated information. So I'm vacating my last order for alternative service. Try to serve him personally again. If you can't get him served personally, then file a motion for alternative service. You do not have to set that for a hearing. So if you just do the motion for alternative service and send me a proposed order, I'll review that in my e-file queue, and we don't have to set that for a hearing.
Okay, Judge.
Okay. All right. Good luck to you.
Thanks. You too.